You work your whole life building something worth keeping, and then one mistake, one overlooked document, one outdated beneficiary form can unravel everything you spent decades creating. That's not a hypothetical. That happens every single day to retirees and near retirees who thought they had things figured out. Today we're going to walk through exactly what you should do and exactly what you should never do when it comes to estate planning for your retirement years. And if you stick around to the end, you'll understand why the single best investment you can make right now has nothing to do with the stock market. Let me start by reframing something. Most people hear the words estate planning and immediately picture death paperwork. If that's what it was, I'd mentally run the other way as fast as possible. But that is the wrong picture entirely. Estate planning is just as much about protecting you while you are alive as it is about what happens after you are gone. Think about that for a second. What happens if you have a medical emergency and you can't speak for yourself? What happens if you become incapacitated and someone needs to manage your finances? These are not distant hypotheticals. These are situations that happen to real people all the time, and without the right documents in place, the consequences can be devastating. So let's talk about the actual steps you need to take, starting with the foundation. Step 1 is understanding what a complete estate plan actually looks like. A lot of people think they just need a will or maybe a trust and they're done. That isn't the full picture. A truly complete estate plan for retirement covers at least 3 phases of your life. The first phase is right now, while you are alive and healthy. The second phase is if something happens and you become incapacitated. God forbid. And the third phase is what happens after you pass. Most people only plan for that third phase, and that's where they leave enormous gaps. Step 2 is getting a durable power of attorney for finances. This is one of the most important documents you can have during your lifetime. If something happens to you and you can't manage your own affairs, someone needs the legal authority to pay your bills, manage your accounts, handle your investments. Without this document, your family could end up in a lengthy and expensive court process just to get that authority. Get this document done and make sure the person you designate is someone you genuinely trust with your financial life. Step 3 is getting a power of attorney for healthcare and making sure you also have your HIPAA authorization in order. These two things often get lumped together, but they serve slightly different purposes. The healthcare power of attorney designates someone to make medical decisions on your behalf. The HIPAA release allows your medical providers to actually talk to your designated person. Without that release, healthcare providers legally can't share information with your family, even in an emergency. That alone could put your advocate in an impossible situation. Step 4 is creating a living will, and please don't confuse this with a living trust. They are completely different documents that serve completely different purposes. A living will, also sometimes called an advance healthcare directive, is where you spell out your wishes regarding end-of-life medical care. Do you want extraordinary measures taken if you're in a terminal condition? Do you want every possible intervention or not? These are profoundly personal decisions, and the time to make them is now, while you are healthy and clear-headed, not during a crisis when family members are emotional and overwhelmed. Getting this document right takes the burden off your loved ones and ensures your actual wishes are followed. Step 5 is establishing a living trust, and this is where things get really important for protecting your assets during retirement. Here is the fundamental problem with dying with only a will, or with no will at all. Your estate goes through probate. Probate is a public court process. It can take months or even years. It can consume a significant portion of your estate in legal fees and court costs. It's stressful, it's contentious, and it exposes your private financial life to public record. People have actually been targeted specifically because probate records revealed the size of their estates. A living trust sidesteps all of that. When your assets are held inside a properly funded living trust, your successor trustee can transfer those assets to your beneficiaries without any court involvement at all. It stays private. It is faster. It is almost always far less expensive than probate, and it gives you an enormous amount of control over how and when your beneficiaries receive what you leave behind. Step 6 is funding your trust, and this is where a lot of people stumble. Creating the trust document is only half the job. The trust only controls assets that are actually titled in the name of the trust. Your house needs to be retitled, your bank accounts need to be updated, your brokerage accounts need to reflect the trust. If you spend money on a living trust and then never fund it properly, you essentially have an empty suitcase. Your assets could still end up in probate anyway. Now let's shift into the mistakes, because knowing what not to do is just as important as knowing what to do. Mistake number 1 is relying on a will as your primary estate planning tool. A will does not avoid probate. A will actually guarantees probate. Your will becomes a public document. Anyone can access it. Every potential beneficiary, every creditor, and sometimes complete strangers end up involved in the process. Family conflicts that were manageable suddenly become legal battles. There are documented cases of families fighting in court over items worth almost nothing in dollar terms, simply because grief and emotion turned a simple distribution into a war. A will has its place in a complete plan, but it should not be carrying the whole load. Mistake number 2 is using generic online documents. The appeal is obvious. You can get something done cheaply and quickly. But template documents frequently lack the specific provisions that protect your actual situation. They often have no provisions for a spouse who might remarry after your death. They may lack special needs trust language that could unintentionally disqualify a disabled beneficiary from receiving government assistance. They typically have no legacy provisions that allow you to direct how your assets are used across generations. And they almost always lack the ancillary documents like HIPAA releases and advanced directives that a genuinely complete plan requires. This is one area where cutting corners can cost your family enormously. Mistake number 3 is putting the wrong assets into your trust. Not everything should be retitled into a living trust. Retirement accounts like IRAs and 401ks have their own beneficiary designation system. Putting those accounts directly into a trust title can trigger serious tax consequences. Instead, you'll generally want to name individuals as primary beneficiaries of those accounts, potentially naming the trust as a contingent beneficiary under specific circumstances. Life insurance and annuities also operate under their own beneficiary framework. Understanding which assets belong in your trust and which ones are better handled through direct beneficiary designations is something that genuinely requires professional guidance. Mistake number 4 is failing to coordinate your beneficiary designations with your overall plan. This is a quiet killer. Your estate plan documents say one thing, but your old life insurance policy names an ex-spouse. Your IRA still lists a parent who passed away years ago. Your brokerage account was set up before your second marriage. Beneficiary designations override your will and your trust, so if they are outdated or inconsistent with your actual intentions, the consequences can be irreversible. Review every beneficiary designation you have and make sure everything aligns. Mistake number 5 is treating a living trust as an asset protection tool during your lifetime. People sometimes believe that putting assets in a revocable living trust shields them from creditors or lawsuits while they are alive. It does not. A revocable trust offers no creditor protection for you personally during your lifetime because you still have full control over those assets. Asset protection for yourself requires different strategies and different structures. Your estate planning attorney can advise you on what actual asset protection looks like given your specific situation. Mistake number 6 is choosing the wrong trustee without thinking through the consequences. Naming your children as trustees without any oversight structure can create serious problems. Statistically, windfalls cause financial harm to a significant number of people who are not prepared to manage sudden wealth. Having a professional or institutional trustee involved, either as the primary trustee or as a co-trustee with oversight authority, can protect your beneficiaries from making catastrophic financial decisions with their inheritance. Mistake number 7 is waiting. This is the biggest mistake of all. People tell themselves they'll get to it when things settle down, when they have more money, when they are older. But incapacity and death don't send advance notice. Every month you delay is a month your family is unprotected. The documents you never got around to doing are exactly the ones your family will desperately wish you had completed. Now here's the honest truth about all of this. You could spend time piecing together bits of information online and attempting to put something together yourself, but the complexity of properly coordinating a living trust with healthcare directives, beneficiary designations, power of attorney documents, pour-over will provisions, and your specific asset profile is genuinely a professional-level task. An experienced estate planning attorney understands provisions you have likely never heard of. They know how to structure trusts so your surviving spouse is protected, while also ensuring your children from a prior relationship are not accidentally disinherited. They know how to craft legacy language that reflects your actual values and goals. They know how to protect a beneficiary with special needs without inadvertently disqualifying them from essential support programs. The cost of getting proper estate planning done is quite modest compared to the cost of getting it wrong. What you spend working with a professional is almost always a small fraction of what probate alone would cost your estate, to say nothing of the legal fees from family disputes or the tax consequences of improperly handled retirement accounts. So here's your action plan going forward. Schedule a consultation with a qualified estate planning attorney, not an online document service, an actual licensed professional who specializes in estate planning. Before that meeting, make a list of every asset you own, every account you have, every existing beneficiary designation, and every person who is important to your plan. Come to that meeting with your questions and with an open mind. Then take action on what they recommend. Review your plan every few years or whenever your family situation, your financial situation, or the tax laws change significantly. Building wealth over a lifetime is hard. Protecting it doesn't have to be. The steps are clear. The tools exist. All that's left is making the decision to take this seriously, and making that decision right now. I hope you got a ton of value out of this video, and if you did, please watch my comprehensive guides of financial freedom starting from nothing video, which you can click on right here. Also, please consider liking and subscribing, and drop your own thoughts and ideas in the comments. My name is Flint, and I will see you in the next video.